inshallah.
Bhai, we're ready? Good? Okay. Okay, Assalamu alaikum, everyone. My name is Danish. Shah, can you hear me? I'm a lawyer in Regina, and I maintain a practice now between Regina and Toronto, so I go back and forth. We have an office in Regina, and we have an office in Toronto. So the my intention for doing this talk was this was a topic that had been discussed that we should talk about for quite some time. And one of the reasons I wanted to raise and bring this topic up was to educate and uplift the community. Because one of the things that I found that there was a lacking in information that needed to be passed. And by passing that information, we'd be able to uplift the community. I'm doing this only for the sake of Allah subhanahu wa ta'ala, and then only to support the iOS. And I can tell you that I have been a supporter of iOS since 2013 when I originally moved to Saskatchewan. And I've been a member, been a part of the iOS, and then even my wife was on the board. And I see a lot of people that have been a supporter of iOS for quite some time. And the reason why I say these comments before I get into my talk is as I get older, one of the things that always kind of has started jumping out at me is like, what if we're doing what we're doing and living our day-to-day life, then what is our purpose? What is the other external purpose that we have? And there's a Greek proverb that has jumped out at me, and it says, a society grows great when old men and women plant trees where whose shade they know they will never sit in. So there are certain things that we do or certain things that we create that we know that we will never benefit from, but we do it for the sake of benefiting others. And if you think about it from the perspective, from an Islamic perspective, Huzur Sallallahu Alaihi Wasallam and the companions, their efforts and that they made created shade for billions of Muslims around the world today. So from the time where they started to where they are now, they allowed us to create this shade. So I appreciate the iOS, and I appreciate that they have been trying to plant trees to create shade for future generations, for this future ummah. And if we look around the room, there's three segments of people. So I'd like to say three things to all three segments. To the older generation, I'd like to say thank you. Thank you for the shade that you've provided us. And thank you for the efforts that you've made that have led us to have access to a space where we can come and where we can pray and have access to a community and resources. To the younger generation, I want to say everything you see here before you is yours. The mosque is yours, and the institutions that we are building are yours. But you also need to be involved in everything that is happening today, because while all of us will move on, you will inherit these issues, these institutions. So you are the next custodians. So you need to be involved. So if you have something that you can do, you should be doing it now. And to my generation, I would suggest that we have the biggest responsibility, because we have the time and the energy to create that shade for the next future generation. And we must expend our time and effort, because we will be asked by our Lord, what did you do with your time? And what did you do with your money? And what did you do with your effort? So all of us will be asked these exact same questions. So I start this introduction on shade because in Islam, our deeds are a shield that will also shade us from the hellfire. So, that being said, how many people in this room, I want you to raise your hand, tell me when you know you will die? How many people in this room know when they will die? How many people in this room know that they will live to 90 years old? Raise your hand. How many people in this room, raise your hand, if you know you will live to see next Ramadan? Nobody in this room knows when they will die. And that is the thing that is the most important, is the time and energy that you have right now. You need to expend it because you will be asked about it. And as part of any other obligation in death, there are also Islamic obligations. So the last time when we came, the thing that we covered was what is a will. We covered the formalities of a will, what is an estate, and what goes into an estate. So for the people that weren't here the last time, I'm going to quickly kind of go over this refresher before we move on to our next topic. For a will is simply a document that allows you to write out what your wishes are upon your death. And that's all it is. It's simply a document that says, if I were to pass away, this is what I would like my wishes to be. I would like for my debts to be paid. I would like for my money to go to person X. I would like person Y to manage my money. And that's simply what it is. And in the province of Saskatchewan, there are two ways you can have a will. And one way is called the holographic will. And a holographic will has to be in writing. And a holographic will, when it is in writing, it has to be in your handwriting and it has to be signed by you. And that's what's a holographic will. In a non holographic will, you have to have it could be written or typed out, but you need to have two different signatures. And there are two individuals that will come in and witness what your wishes are as part of that will. A famous example of a holographic will in the province of Saskatchewan is there's a farmer. He's in the field, he's in the middle of nowhere, and he has a heart attack. What is he going to do? He knows that by the time he goes to call somebody, whatever's going to happen, he's going to be gone. And he doesn't have a will. So he takes a screwdriver, he gets to his truck, and he scratches it out on it. I leave everything to my wife. And that bumper became his holographic will. Because in that contemporaneous time and space, that was the only way to define that there's nobody else that could have come and did what he did. But that man was lucky because even within that situation, he had the time and the ability to think about what I need to do and do it in that moment rather than thinking, oh my God, what do I need to do in the next steps? So a will is simply a document that tells you, that tells the world, what are your wishes in terms of who's going to manage your affairs. Now, as far as what is an estate? An estate is all the money or all the assets or anything that remains in your name after you've passed away. So if you have a bank account or you have a house or you have anything and it remains in your name after you've passed away, it forms part of your estate. And the information that I provided last time is when you pass away in Canada, there's two taxes that you have to pay. There is the personal income tax that you have to pay. And then the second thing that you have to pay is you have to pay probate, which is estate tax. So you have to pay, for every $1,000, you have to pay $7 in taxes. So that's a separate tax on the income that you've made. That's tax on your wealth. So anything that remains in your name, you will be taxed on it. So a way to get around that situation is where you can have a beneficiary system. So, for example, if you own, a, let's say, a bank account with your spouse or somebody, that bank account doesn't remain in your name when you pass away because there's somebody that's joint. So, if somebody is joint on the bank account, that means that bank account is not yours. You passed away. Now that bank account 100% belongs to somebody else. So, if you have certain vehicles that can be joint and you do that, that means you can have it when you pass away, you are at zero legal obligations. But the sheikh will come along and tell you that, so what if you have resolved your legal obligations? What are your Islamic obligations? Because if you and your spouse have a house and you're joint on the house, and you and your spouse have a bank account and you're joint, now you have passed away, everything's in your spouse's name, but have you fulfilled your Islamic obligation and the Islamic inheritance obligations? You have not. Therefore, you will need to have an Islamic will that will say, this is how I would like my assets to be distributed, taking into consideration the Sharia and the percentages that are required. So, if a husband and wife were to draft their wills in a way that if they get 100% of all of their assets after they've passed away, and they write out the responsibility is whichever spouse remains alive, then they can pass on that responsibility to that spouse, and that spouse can carry out those wishes, and that is Islamically permissible. That's what we covered the last time. So, majority of what we covered last time is that anything that remains in your name, if it still remains in your name after you've passed away, it forms a part of your estate. And if it remains part of your estate, uh, currently the court cost to have someone appointed to handle any money that is left over. Let's say, let's say a husband passes away and he's only on the house, and he has wife and children, and let's say the wife's not on the house. If the husband passes away and the wife wants to sell the house, the wife cannot sell the house because she doesn't have any legal documents that suggest that she has ownership. So she will then have to use her husband's will to then pay tax on it, tax on the value of the house. And then at the same time, she will have to apply to court for a certificate of appointment to then be able to sell the house. So by the time she goes to sell the house, you are probably looking at $30,000 to $40,000. Then when you go to sell it, then the realtors will come and they will also take their money. And then the lawyers will come back again, will take their money again for the sale of the house.
Wow.
So that single transaction of when you've passed away is probably going to cost you between $60,000 to $70,000.
Allah.
So, one of the ways in the new topic that I would like to cover, uh, there's three additional topics I'd like to cover. The next topics I'd like to cover is called a living will, because we didn't talk about that last time. I would like to talk about guardianship, because that's becoming a major issue within the community. And then the third topic I'd like to cover is, how do we avoid finding ourselves in situations where we now have to pay all these lawyers and taxes and so on? How do we avoid this situation? So the simplest topic, let's talk about a living will. So a will is only a document that is required for when you've passed away. But there are so many times when someone, and the doctors in the room will tell you, someone is legally alive, but they have no capacity, meaning they're either bedridden or they don't have the mental capacity to make a decision, or they physically can't make a decision. So they need to have something called a living will. And a living will is a power of attorney or a power of attorney for care that is required so that in the event something happens to you, who then gets to make your decision? Because if something happens to you, and let's say you're in a car accident, who gets to make that decision? Who will pay your bills? Can somebody from the mosque go and start talking to the bank on your behalf? Will they say, hey, I'm brother so and so from the mosque, I'm trustworthy. Why don't I just give me this guy's money? Can you do that? No. Nobody's going to take you seriously and nobody's going to deal with you unless you have a power of attorney for property, meaning you have the ability to go access that individual's bank account and then be able to make decisions on their behalf. And that's power of attorney for property. And then there's a separate one for power of attorney for care. Now, both of these documents are dangerous documents because you don't want to just give somebody the power of authority while you are still alive to go and start making decisions for you. Whenever there's difficult situations like this that come up, Shaitan will always come up and be like, maybe just take $50 here and there. Right? So suddenly the brother who has the power of attorney, well, money will start going missing. Um, so any document like that, we recommend that what needs to be done is you need to have a medical doctor come in and say that this power, whoever has that power, whoever you are deeming to be trustworthy enough, they have to have a medical note that says whoever is the individual whose power you are now taking over, they no longer have capacity, right? Because if they're still around and all of a sudden you start making decisions for them, then there can be issues. So in that situations, in most cases, if you are married, you have a husband or a wife who become the power of attorney for property or power of attorney for care. But we always recommend that you have a secondary person because who are you most likely to be traveling in a vehicle with? Your spouse or partner. So the statistics of you being in an accident with your family is high because those are the people you are most likely traveling with. So you also need to have a backup of who handles your affairs because the bank isn't going to care that your bills aren't paid, or SAS Power isn't going to care that you're not paying your power, right? So these people will want to make sure that their bills are paid. So that is something that needs to be done. So there needs to be a backup. And that's either for power of attorney for care or for power of attorney for property. The other thing that is an issue, that's a major issue that's happening is if there are if the both parents pass away and you have children under the age of 18 and you have not designated where these children or who these children are going to be taken care of by, then the province will step in and the Ministry of Social Services will take these kids and these children will end up in foster care. And sometimes the children will end up in foster care. Let's say there's 3 children, you could have 3 children ending up in foster care in 3 different places. And Muslims aren't signing up for foster care. So these children aren't going to Muslim homes in foster care. So these children are now going to non Muslim homes in foster care. So, one way to avoid this issue, because nobody knows when they're going to pass away, if you have children under the age of 18, you should write out who is going to be the guardian of the children under the age of 18. And there are two guardians. And if you think about it, Huzur Sallallahu Alaihi Wasallam was an orphan. He had a guardian. There were people that were in charge over his money, there were people in charge over his care, and there were specific people that had specific responsibilities. And that's why Islamic ruling and fiqh ruling on taking care of the monies or whatever is owed to an orphan is so high, because there's very specific responsibilities, and it's very easy to come along and take something from someone else that doesn't have a voice. So, if you have somebody who has a family and their children are under the age of 18, you should designate a care guardian. This is just a basic terminology. There's various other terminologies, but it is basically somebody who will be in charge of the children under the age of 18 if you happen to, if both the husband and the wife happen to pass away. You can also designate a property guardian, meaning the individual that is going to be looking after these children should also look after the property of these children, which is whatever money has been left behind. That money should also be left for them. Now, the common thing that I would like for people to consider, factors to think about when you're picking a guardian. Just um, pick someone who's in the country. Don't pick someone who's in Egypt, right? Like if you're sitting in Canada and your children are here and you pick someone in Egypt, do you think that they're going to be able to come to Canada and now in this emergency situation going to be able to like look after the kids? No chance. Um, Pick someone who can look after your children on a full-time basis in this situation. Don't pick somebody who doesn't have the capability in this situation, who can't then look after them. Don't leave them with somebody who doesn't have the financial resources to look after their own children. Don't leave it as a surprise after you've passed away that all of a sudden someone's contacting you that you are somebody's guardian. News to me, they never talked to me about this issue. We never had a discussion about it. We never knew about it. Now, when I say children and when I say under the age of 18, this also applies if you happen to have children that are disabled or need extra care. Because just because someone is under the age of 18 doesn't necessarily mean that they need a guardian. You could have someone above the age of 18, you can have someone who's 35, and maybe there's some other issues and challenges that they could still require a guardian. Um, Sometimes it is also better when you are appointing or thinking about appointing somebody as a guardian for care to appoint a different person to appoint a property guardian. Because if you leave the individual who has the ability to look after your children, you also leave them with all of your money. We have seen situations and circumstances where there's no accountability, there is no anything, and all the money gets mixed in and the money's gone. And now these children become a burden. Um, Lastly, especially for property guardian, pick someone who's good with money. If you know someone who's already bad with money, don't pick that person, right? So I know everything that I'm saying sounds scary, but because none of us know when we are going to die, These are all variables that we need to think of and have built in into a document so that in the event of a worst case scenario, you have all these various clauses in there that protect you. Because if you think about it, if you do not make the proper arrangements, then you will be held accountable for the fact that now, recently I got a message that there's 3 children in BC, I think 6, 8, and 9. The 2 parents died, they're in foster care, and they have nobody. So if the proper planning wasn't there and there is no guardian and the parents didn't leave enough provisions, these children will likely end up as non-Muslim because they will not be going to a Muslim foster care. They're not going to be raised as Muslim. They're not going to have the choice to eat whatever is put in front of them, they will have to eat. So once they are in the system, that is it. So if you do not have relatives or if you do not have people you know, reach out to people who are your friends, members of the community, people you align with, and say, I would like for you to be appointed, or I would like to choose you in the event something happens to me. I don't know. I trust you, and vice versa. But have these conversations. And the reasons why I'm telling you this, so that you can think about these conversations or think about these scenarios that you haven't thought about, so you can start discussing these things with your family. What happens to us in the event I go? Again, none of us know when we will die. Um, on the issue of estate planning, there's there's documents that I provided, uh, which is just some basic terminology. Um, the easiest thing with estate planning is all wealthy people die with $0 in their pocket, and that's the best estate planning. The best estate planning is if you are able to leave your money or leave your assets in such a way where it is transferred to somebody else, then you have nothing in your pocket and therefore you have no obligations. So if you have, for example, if you work and you have a pension, you can designate a beneficiary as your spouse. If you have children above the age of 18, you can designate those children and you can even designate the percentages you want for those children. Nobody in Canada will come and police you if you are choosing the Islamic percentages on your beneficiary form. So for TFSAs, RSPs, workplace pensions, anywhere where you can designate a beneficiary, that means the money that is assigned to your column, once you pass away, it will be given to whoever is the designated beneficiary, and you have $0 when you pass away. So that means, as an example, if you are a government employee and you have a pension, maybe let's say RSPs, TFSA, a joint bank account, and a house. If everything is, if those accounts have a beneficiary designation, all those accounts go to zero and that money gets paid out. The joint bank account goes to whoever's joint on the account and they become 100% owner. And then for the house, if your spouse is a beneficiary, sorry, a joint tenant, they become ownership, they retain ownership of the house. And because they retain ownership of the house, you have $0 in column. There is no probate or estate tax that you have to pay. The only tax at that point would be whatever income was earned at that time. Now, if life is more complicated, you can have things called a co ownership agreement where you own something with somebody else, and you have that written down that we were owning it together, right? So you can have it and you can say, we own this, and both of our names are on it, but really it belonged to somebody else. And I'm just holding it in place for that person. So that's one way where you can get around that system. Trust agreement is another way where if parents and children decide that they are going to own property together or they're going to own everything together, then within that individual's lifetime, the children don't have any rights over that property or that account. But upon the parent's death, then you can say, this is person X's responsibility, and that person will now then deal with the issues. So, a good example of that is, let's say there's a family and there's a brother and two sisters. Adding every single child's name on a house becomes very costly. So, a good way you can do some estate planning would be, you can sign a trust agreement, you add one child to the title. So, when the parents pass away, that child becomes 100% owner, but they will have an agreement that they will pay out the other siblings Islamically. The biggest reasons fights happen is because we refuse to have agreements signed. How many times have I heard where someone back home has some property that they're fighting about with some relative, and it's been never ending for like 10 years, all the time, because things are never written down and parents don't have the difficult conversations they need to have with their children when they are alive, or the proper arrangements aren't made when you are still alive. This is what we have. This is your responsibility. We are going to write out a document setting out your obligation to your siblings. We will document it, which is all very Islamic. I'm only talking from a legal perspective, but everything also Islamically, have a witness, write everything down, right? All of these things are the same. So, um, I think we want to leave a lot of time for questions. So maybe we will, um, I'll leave time for questions at this point.
So for one question, so is it is it recommended to have a power of attorney person from outside your immediate family in case the entire family dies together? Example, airplane crash.
So that's a good question. So what we do is, even the individual writing the document doesn't know whoever they're appointing, are they going to die first or are they going to die first, right? So in any given scenario, you have no idea who's going to die. So when you are writing these documents, you have to write out, I'm going to I'm going to appoint person X, the best person, my number one choice. In any given scenario, you should say my number one choice for any job in a power of attorney situation or even an executor situation is person X. If person X passes away, I'm going to pass on that responsibility to person Y. If person Y is also not available, then person Z. So if you do it this way, then you don't have to keep coming back and changing these documents because it doesn't make sense. And you can have a will written for somebody, and let's say they write it now and they don't change it, and life goes on and things have changed and things, the law says whatever was the last legal will that was written, that's what is being followed. So top priority, one, two, three, in every document you should have that. Just on that question, even in a beneficiary situation, let's say you say you have two children or three children, I'm gonna have monies be given to my children. We can also have it built in where if you have children and your children were to pass away, then that share will be held for their children's children in that scenario. Any other questions? Yeah.
Just as last session you told this will is just instruction, not a legal document. But the power of attorney is a legal document, right? But it still needs a court order to the person who gonna decide what he's gonna do or either sell the property or whatever the decision the designated guardian wanna take.
So so it's a good question, but it's a complex question. So if a will is a legal document and there's a legal format, and the law says there's a legal format that you have to follow in order for it to be valid. But if somebody passes away, you can't use a will, for example, to sell the deceased person's house, right? Because there could be other people that can come along and say, we also have authority, and then the court needs to decide who has that authority. But in a power of attorney, it's a different scenario because in a power of attorney scenario, if that individual is still alive and you have that legal power of attorney, you technically, if the power of attorney gives you unlimited authority, you could sell that individual's house while they're in a coma or they're bedridden because you may need that money for whatever medical care or other care that they may need. So that power of attorney can allow you greater power and you don't need to go to court, right? The only reason when someone passes away, you have to go through the court is because one of the things I talked about is the first thing that the government comes is they want their tax, right? So when you pass away, even before you can go to court to get the document for certificate of appointment for a state trustee, the government says, okay, well, give us our probate, give us our wealth tax. So technically, if you haven't passed away, that tax obligation hasn't been triggered, right? So it's interconnected with tax. Does that make sense? Yeah. And yeah,
So I'm just wondering about for the case of a will.
yeah.
Um, I have heard about these generic Islamic wills for a couple of mosques. I'm just wondering about their legality in terms of are they legal across Canada or is it a province to a province? So it's not like a generic where you just write name is Islamic,
Right.
you just put the legal name and guardian and that's it.
See, those, every province has its own laws on how you establish your will. And those precedents sometimes the source of the document, sometimes they work and they don't work. So a lot of times, a lot of these ones that I've seen come from the US and they have a completely different system. So although the body of it might be Islamic, if it's not accepted, then that creates a problem because there's the way the law treats it is either you have a will and your wishes are followed, or you pass away and you die intestate, meaning like you don't have a will. And if you die without a will, then the law will basically make the divisions for you. So for example, Islamically, if the percentages are different for boys and girls, the intestate act for if you die without a will, it will divide everything based on 50-50 or so on. So right now, what we are trying to do is we are trying to create wills where we create the wills. They're the Islamic wills, and that once they're done and created, anyone that we help to do a will, 100% of that money will go to the iOS New Moss Fund. Um, and I think I haven't fully decided what the cost will be, but the way I would do it is I would do it as a package where you would get a legal Saskatchewan Islamic will and a power of attorney for care and a power of attorney for property. And whatever the charges are, 100% of the money would go to the IOS. And I'm trying to figure out if we can have it where if it's a if the money is directly paid to the iOS, then technically it's a tax charity thing. So the logistics of starting this process is to figure that out so I can help facilitate the new Moss Fund. Any other questions?
I understand that the power of attorney,
Yes,
the power will stop once the person dies,
that's absolutely correct. So
then the will kick in.
exactly. So once as long as the person remains alive, the power of attorney for care and power of attorney for property will 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 go on forever. And then once that person passes away, then the will kick in.
Who's the executor?
Executor. So in a will, there a will has basically three sets, three sets of people. So the first set of people is the executor is basically your manager. The executor in your will is the individual that is going to be deciding and managing all of your affairs. So, for example, once you pass away, if you have passed away and now someone needs to come in and deal with external like places, this individual will talk to the if they need to go to court or talk to the accountant or need to go to anywhere else, they will become your manager. So the exam at the same time, guardians, if you have children or if you have children under certain situations, you say, if my children are underage, then here are these people who I decide as guardians for their care or guardians for their property.
Well, this trust agreement or trust
Right,
and all that development, which is the inheritance,
right.
rather than making a will, because the trust usually allow automatically transfer the property without the court order or not.
You need to do everything because think about it this way. At any given time, all of us have so many different things in our names, and we have no idea when any of us are going to pass away. So even if you do all your estate planning, none of us can control if something remains in our name after we've passed away, right? So you do the will Islamically, but you can still do your estate planning in an Islamic manner. You can say, I will leave this to this kid, or I will leave this to my parent, or I will leave this. But if something remains outside, let's say you in the middle of a transaction, or you are about to do something and you're driving there and you die, right? The will is just there as a catch-all to catch everything that remains in your name if you have passed away. The other thing is in a trust agreement is like sometimes, and this is a very new thing that I've started seeing, is let's say a sister comes to her brother and says, can you be my guarantor on my house? Or can you help me get a mortgage to get a house? So the brother helps the sister dies, now the brother's the owner of the house. Shaitan comes along and says, well, this is your house. You helped your sister get the house. What protection does the sister have in that scenario? The brother's never paid for anything, but his name was on the mortgage and his name was on the title. But if his name was on the mortgage and his name was on the title, who's the eventual owner? At the end, he is. So if there was no document that clearly set out that he was holding the house in trust for his sister, legally, the law will say the brother is the owner. And you know what happens in that case? Shaitan will come along. Always the case when money. And the brother says, well, it's my house. Get out. So you have to be thinking about all these different things because you don't know when you're going to die. That's what I say. Any other questions?
Is there any form
Sure, good.
format where I will, like
combines the Islamic direction of the law,
It's-
from Saskatchewan.
yes. So the document that we are creating, which will be facilitated through the iOS, is that going to be that document? So it'll be legally valid, Islamically double checked. The Sheikh will oversee that. I will oversee the fact that the legal component is there. The Sheikh will oversee that the Islamic component is there, so that when we are presenting it through the iOS, then people can have peace of mind that legally and Islamically, both of the things that they need to be cognizant of is taken care of, right? And then if it doesn't have to go through the lawyers, then the money goes directly to the iOS.
The court won't object to the
No,
principle, like the girls will have
Mm.
the boys will be. They won't object
they,
to that.
the
The human rights will be.
right. The court will not, unless one of the children want to specifically challenge it, and that's a separate issue. But legally, if you decide to leave all your money to your dog, you could leave all your money to your dog. I would advise you not. I would advise you not to do that. But you could leave all your money to your dog, and there's nothing your children could do about it. They could challenge it, but and this happens all the time. As parents get older, we had this gentleman. He was 95, and once a month he would call us to change his will because his son wouldn't come and visit him enough. And he was like, he's not coming and visiting me enough. I want to change my will. And be like, him and his wife and us would have to convince him that no, don't do that. Just think about it. And then, but
Which mosque did he go to?
he was Anglican. He was going to a church. Yes.
Your last session, you mentioned about it's better to have a separate corporate will.
Yes.
Now, if you have a will, does it cover the corporate or if you have
You, you can specify all assets, right? You can specify all assets, but if you do it where you have a corporate assets and you do it in that way, then it is better for tax reasons. Like, for example, one of the other things I mentioned, that if you have assets in Alberta, it is also good to have a separate Alberta will, because Alberta's probate is a lot lower, so their wealth tax is a lot lower than Saskatchewan. So technically, if you have property in Alberta and you want to try to mix it all into Saskatchewan property, you might end up paying more tax. So some people, what they will do is they'll have a Ontario will, Alberta will, Saskatchewan will, so they will have it different ways. But to keep it simple, because again, we don't know when you're going to pass, initially it's just easier to say all of my assets. And the other thing I think I provided the last time as a tip was, on a yearly basis, even though you may have a will, your will doesn't say what assets you have. It's just percentages, right? So if you have something and it's changing, keep a piece of paper that says, what do I have and where do you have it? So that once you've passed away, your family isn't playing a guessing game of like, what is your password? What do you have? Where is it? And the new issue that's happening is almost nothing is coming in the mail and almost everything is coming electronically. And we keep having to change our passwords every 2 weeks, I feel like, because of all the phishing and all the other stuff. So that if nobody can access what you have or where is it, how are they going to even access it? Right? So you need to also keep updating, aside from the will, what is it that I have, right? In a beneficiary system, you will get a notification. But let's say you have something and your children don't know what you have and where it is. So they can't notify them that you've passed. So if they can't notify them that you have passed, how are they going to get access to money that they don't know that exists? So you got to start having conversations about the things that you don't want to have conversations about. death. Yep.
I believe I may have asked this question again in the last session, but is it possible, like the thing that you just mentioned, that we keep a list of all our accounts?
Yep.
Maybe in a shared Google Doc, we don't have to specify what's in there and whatnot, but at least there's something that we can share with our kids so they can, they can see what's there. And then they can use that to kind of make sure that there's nothing missed at an event that.
Right. And that's a great point, because at any given time, more and more, we have so many different accounts, right? You have insurance, you have like your cell phone, then you have internet, so many different things that we're connected to. And if the right notification isn't being sent out, you will keep getting bills. All these corporate companies will continue to bill you until someone notifies them that, hey, this needs to be done. The Google Drive thing is good and you can do it electronically, but if your family doesn't know the access to your laptop password or your phone, or they're not going to be like hovering with your face when you're dead to try to get access to your phone, right? It's better in my mind to have a piece of paper that you keep updating, because electronically, this information could be easily gone. So if you have a piece of paper and you tell everyone where this piece of paper is and you keep updating it, to me, and you have a little fireproof safe you can buy from anywhere, just have a look what you have, where is it? In the event I die, go to this little thing. The information's there. Most important document should be in a fireproof safe in any event. Yep.
So initially, I'm sorry I missed the last session.
Yeah.
I probably had more detail on this, but when you started, you said that there are two kinds of wills, and one will is where you have witnesses. And so once if I prepare such a document on my own, why do I need a lawyer to do the will?
You don't. The only reason, the only difference between a lawyer versus non-lawyer is if there are complexities and discussions you need to have on how you want to set things up, right? Because if you don't write out who the money is going to be going to, right? Let's say in a benefit, let's say you write out a holographic will and it says this is where my money is going to go to Islamically, but the document doesn't continue and your entire family is gone. Your money technically under the Intestate Succession Act can go to one of your family members who you haven't talked to and you hate. So the government will come along and say, well, the Intestate Succession Act says your whole family's gone. You haven't specified anything else. And now this money is going to go to somebody else. So the purpose of what the lawyers is supposed to be doing is technically supposed to be looking at all the various scenarios that things could possibly go wrong and have that. So like a good example is what happens if the children die before the parents, right? So does their share get absorbed? Now, does that share go to the other sibling? But what if they have children? What if they have a spouse that they have to support, right? So it right now, a holographic will immediately, if you were to make it, it's great. But in the long run, it's better to have a conversation and just have something more comprehensive. Really, this is to protect everyone in the long run from a worst case scenario and really to help them save on costs.
From your sorry.
Yeah.
From your experience, where should we keep wells? Like, is it in the bank?
So this is a good question. So most lawyers, what they will do is they will they will have a will safe and they'll have wills in the safe, and the original copy stays there because now even regular signatures are so easy. Printers have become so good that you could easily duplicate signatures. So what happens, what we do is the court in Saskatchewan has a will registry. For $10 for life, you can put your will in there, and that's where it is. And you'll get a little certificate that your will is there. Now, the good thing is, if your lawyer is disbarred because he's run away with your money to Pakistan, and now he's living a very good life, your will be safe there, right? So, or somebody's passed away and the firm's gone. As long as the court is there, your will be safe there. So, my suggestion, even with the project that I'm trying to do with the iOS, is that any will that is done would be sent. The $10 cost would be incurred. You get a certificate, you know where your will is. You can write a letter to your kids or your family. In the event something happens to me, here's where the document is, here's the information, and that's it. It's a lot easier and safer way to just keep everything together. Yep.
So how do you go about making a will that's valid in Saskatchewan and in the US at the same time?
My suggestion would be because every state and every place has its own laws on how assets and property is dealt with. Uh, I would I would do a will in every place based on tax consequences, right? And the reasoning for that is, let's say you have assets in Saskatchewan and Saskatchewan taxes you less, but now your family all lives in Quebec. So if you decide to do everything in Quebec, you will pay a higher tax, right? So really that's a tax dependent thing. So me personally, I have a personal will and I have a corporate will, because even if you have a corporation, you may have partners or other people who may be involved, who may have a say, and they also need to be involved in what happens in the event that you die, right? So the complexity of that is you technically need a will for every situation. Yep.
How is, okay, so the banks have your cash, they have their offices
Yep.
over the country. Let's say you have $1 million in cash, you are residing in Saskatchewan, but is it possible that you can, how is the residency of the cash decided in your bank? You know what I mean?
That would be based really honestly wherever you've been residing for quite some time. So cash, it becomes really difficult, right? It's wherever the account is registered. So for cash becomes really difficult, but like for physical property, that's a different.
Is there a way to, let's say Alberta has the lowest taxes,
Yeah.
taxes. Is it possible to kind of, make sure that you can kind of register some of your assets with cash in there and then?
See, if you have actual property and you maybe have bank accounts and you do it that way, you could probably do it. But the problem will be every year we have to declare where we are residing on our taxes, and CRA is always going to come after you, right? So this is why I said if you have certain things that are in Alberta and you keep them separated, it's easier to create that justification that this is Alberta and this is Saskatchewan, because otherwise then it will create a issue with CRA. And then once CRA starts looking into everything, it'll just create more problems.
Is it true? I don't know actually, but in a social media, I don't want to take the name of the religious, but influential religious group, they are promoting, if you want to save your inheritance from the different kind of the hazards like this is past use, even they claim if you want to avoid the capital gain, so just make your inheritance in a trust so you can save every hazards for them after your death. That's true, or just even the people.
Listen, for every action there's a for every action there's a reaction, in Canada, and tax laws are very, very complicated. So think about it this way. If let's say you have a house and some money, a house in Canada, if you bought it and now it's gone up in value $7 million, just as an insane example, there's zero capital gains. If you were to move that same property into a holding company or corporation, and now you're realizing on that value, you have to pay. So you may be saving on inheritance tax, but you now have to pay capital gains, right? So for every single thing that you're trying to do, there'll be there'll be tax consequences, right? The other issue will be right now, if you have certain assets, you may not have to pay corporate tax. But if you even have a holding company that's holding a lot of assets, and maybe there's some income being generated, or maybe there's something else that's happening, every year you'll have to pay a separate tax on it aside from your income. So it's complex. I think the easiest thing to do is um, keep it simple unless you have a lot of assets that you are trying to save money on. The easiest thing is when one partner passes away, have it passed on to that person, right? So if husband passed away, everything goes to the wife, or if the wife passed away, everything goes to the husband. There's no tax, there's nothing. And then when the last parent is alive, then you can have a proper planning about what needs to be done. Do I need to have a trust agreement with my children? Do I need to have all of these different things? Do I need to kind of settle my affairs in such a way? That's a better way of doing it without making your life more complicated. Yes.
Someone said that Quebec has a different will and laws. Even joint accounts in Quebec gets a restricted non-beneficiary designation in Quebec.
Right. So every province has its uh, own legal system and own legal requirements. And so far, everything we're talking about is only for Saskatchewan. So the information I'm providing is only for Saskatchewan. Yes.
Let's say some parent wants to start something like this, a trust or whatnot. Where would they go? Where would their first steps be? Like, where would they find the documents? Who should they talk to?
See, it it depends on what you call it. What is it that you want to do, or what you call a trust? A trust is if if you, let's say one brother goes to another brother and say, look, I cannot finance the vehicle, or I cannot do this, or I cannot do that. You write up a document saying, I am going to buy this vehicle under my name, but really you're the person whose vehicle it is. So I'm holding this vehicle in trust for you. That's a trust agreement. Anybody can write up any agreement saying, I'm holding something in trust for somebody else. The complexity of the document, or the complexity of what you're talking about, is that, like, what is it that you're asking? Like, are you trying to create where you put all your money in a trust, or are you talking about a single small thing? Like, what is it that you're trying to put?
So, like, it's not be a trust, like maybe even a will. Like, where would like I don't know if, like, let's say it's like a format of something. Like, is there like a is there like a government site where you in a format of like how a will should look like or whatnot, or like
It's very easy. You have your name, you have who the executors are, who are the people who are going to manage your affairs, who the money is going to go to, um, and as when I die, I want these people to manage my affairs. I want all my debts to be paid. Whatever money's left over, I want to divide it in these people. That's it.
you submit that or anything, or
Nobody.
when something happens, do you go to the court yourself with the will?
No. So a will is simply a document that tells the world what your wishes are. In order for you to then utilize the will, let's say if there's an asset that remains, like a house, You would have to go to a lawyer, and then the lawyer would have to apply to court, and then the lawyer would also have to satisfy the government that the taxes have been paid. So probate has to be paid. Then you have to apply to the judge, and then the judge would have to grant an order to then give you the opportunity to then deal with the. It has to go through a lawyer. You can try doing it yourself, but it is so complex that not even every lawyer does it. So, because the judge will want very specific requirements on, because they have to follow the law.
Like a TFSA or RRSP, those we already mentioned our beneficiary and right after our death, the beneficiary is gonna get the money.
Right.
What are the assets those actually need the will, so they have to apply for the court order?
Everything. Imagine if you have a safety deposit box. Imagine if you have a property. Imagine if you have any like piece of land, right? Imagine if you have like like vehicles, right? Like you, nobody's gonna buy something from you unless you can prove you are the legal owner of it, because nobody wants to buy something where someone then comes along and says, well, I guess I want it back. And this happens all the time, where even now there's scams where people will like sell you a car and then you find out the car belonged to Enterprise. The guy sold it to you. You didn't check, and now you've sold a rental vehicle. Your money's gone, right? So the will, the reason why you say all assets is whatever hasn't been transferred, whatever is left behind. It could be anything. So some people will have like, gold is so expensive now, you'll have people with thousands of dollars worth of gold that is sitting in safety deposit boxes. How do you access a safety deposit box if you don't have the necessary documents to access a safety deposit box?
After the person death, irrevocable beneficiaries, they become revocable or not? They automatically become revocable or not?
What do you, I don't understand.
Like most of the time, you have the beneficiaries for your assets irrevocable.
Yes, meaning like whoever, if at the time you had decided that these were, whenever you write your will, unless there's a new will that changes it, those people are it forever. So if you write a will now and 30 years you don't do anything, whatever it says in that document, that's what the document is.
But automatically they don't convert from that.
They don't nothing is converted, because ultimately it's supposed to be your wish, right? Yep.
Share the information. When we are expecting to receive
Uh,
plate.
the inshallah, the template, I'm working on it with the sheikh, and I'm gonna try to get everyone something in July. And then as far as a session on getting people to come in and sign, I'm thinking sometime in August, where I would have nightly sessions, and then where we could come in and just get people to sign the documents and try to get as many people from the community to have just the will to cover everything.
The template will take all those guidelines.
It will be the Islamic guidelines, the legal guidelines, everything. Everything will be in there.
And you are recommending now the children, but not children anymore. And also, they have to write this to the parent or to the family.
Well, I think everyone should have a conversation about, if you are simply saying my children are going to get X, then there's limited participation, right? So depending on how involved your estate is, that's a conversation you need to have, right? So if you are involving them where two children have to work together and be executors, because you can have co-executors, and you don't tell them that, then that's an issue. Or if these two children don't get along, then that's an issue because nothing's going to get done. And then you have to go to court to change, right? So, like, there's a lot of things to think about when making those decisions. And then you got to first have those conversations to be like, what makes the most sense for my family? So, the best thing I would like as my final remarks is we should all start having conversations with our families about what is it that we see that our family needs in the event any one family member were to pass away, right? And this is a major issue if the primary earner in the family passes away or if you have dependent children. It's one thing if you are old and retired and your children are now independent. It's another thing if you are the primary earner and you have independent children and they rely on you and you have a mortgage, right? So we have to think about these things. Yep, last question.
It's like more of like a silly legal question. So when you like you drafted your own will, you talked with your family, like you seem like the formats of what you need on a will. You go to a lawyer. How is it how is it verified that that like this all like the parties involved like this is like a legitimate thing like all the
See, the person, so as you're making a decision, um, you can put anybody down in the will and you don't have to consult them. Obviously don't do that, and it shouldn't be coming as a surprise, like, surprise, person X has died and now you have all this responsibility that they didn't tell you about. You can name anybody you want in your will to be your manager and whatever responsibility you want to put on them, but you should write out, you should speak to the individual and pick out individuals that are going to be competent. For example, like, if you know somebody that hasn't filed their taxes in 4 years, don't make them your executor and make them responsible to file your taxes, right? So choose people and let them know that this is what I've done. You don't have to tell them what money I have or whatever, but choose the right people to be like, I trust person X who's trustworthy, who's good at administrative tasks. They know what they're doing. They're going to do this. They're going to take care of it. They're going to be efficient. They know my family, or they may be able to handle my family if there's internal issues, or you got to think about all these interpersonal issues. If interpersonal issues exist within your family, they're not going to get automatically better when you pass away, and they're going to become someone else's problem. So think about what is currently happening and who do I leave in charge to deal with these issues after I've passed.
how is that document like uh deemed legitimate though like
As long as you meet the legal formality, which is have two independent witnesses, have it signed, and that's it. The law says as long as you have two independent witnesses who have uh, who are not beneficiaries, uh, you're fine. So technically, a good example is I was appointed as an executor. So because I was appointed as an executor, I couldn't be a witness, right? Or if your spouse or somebody you know was going to be a beneficiary, you can't be a witness. That's a conflict, right? So it has to be someone who's completely independent, who's going to verify that you are of sound mind, you're capable, and you're making a decision without a gun to your head, or with the other anybody else in the room, and that's it. That's valid. Last,
That's another one. If a person has assets in multiple countries,
yes.
how that will implications are?
The best thing to do is have a will in each country, in each place, because you don't want to complicate. Think about it this way: if you have assets in, like, let's say, a good example is the U.S. because they're right next door. If you try to bring the money over, but the estate conditions or like the tax conditions are more favorable, you want to utilize wherever it's favorable. If it's favorable to declare it here, declare it here. If it's favorable to do it there, do it there. Right? So it involves everyone.
Last, but when will be the part 3?
But inshallah, August.
That's over.
Yes.
Jazakallah, everyone. So, first of all, thank you very much on behalf of the IOS. I'd like to thank you to Brother Danish, who came all the way from Ontario twice and gave us very important information. And we'd like to thank you to all of you as well, and those who are watching the YouTube channel. So, as Brother Danish mentioned, that inshallah, next session will be in August. It will be another informative session, inshallah. We'll stay tuned, inshallah. We request everyone. Please propagate this program. It is very important, beneficial for everyone. Jazakallah khair one more time. And since it's 12 minutes left, inshallah, for Isha, we'll see you again. Jazakallah khair. Assalamu alaikum.
Jazakallah khair again. Yeah.